My name is Morgan Sheppy. I am the attorney for the Child Advocate Program of Pierce County. So I've been with Pierce County since 2017, the beginning of 2017. And my role as the attorney for the Child Advocate Program is I am essentially support for whatever the guardians ad litem or the child advocates need. So anything from staffing cases, attending court hearings, presenting motions, which is what we're going to talk about today, handling difficult attorneys, attending meetings, just any kind of legal support research, summarizing cases, all kinds of good stuff. So any kind of legal assistance that my team needs, that's my job to provide for them. So I believe there are only 3 programs in the state that have kind of an in-house attorney, and Pierce County is one of them, and that's me. So I'm excited to chat with you guys today. I've kind of got 2 presentations that we're going to do today. So we'll start the first one, then kind of, go through that, answer some questions, do whatever, and then get to our second one. Same kind of scenario. So I'm going to share a PowerPoint with you guys. And then I also have some documents I'll probably drop in the chat, and we'll kind of go through some of those as well as we're talking about things that are going on today. I'm always a fan of questions. So if you have questions at any time, you can either raise your little hand in Zoom, or go ahead and just drop it in the chat, and we'll kind of try and manage those and respond to whatever questions or anything that you have. If you have any technical difficulties, also just let me know. Happy to try and sort that out as well. Okay, so share my screen here. We are going to, all right, everybody see that PowerPoint there? No, didn't hit the right button. Here we go. Oh, you have to hit share. There we go. Okay, cool. Okay, so the first kind of subject matter that we're talking about today is motions practice. So our program does quite a few motions. I actually keep track every year of how many motions that we do. But I think probably because we have an attorney with our program, we're probably more prone to doing motions than many programs. So we kind of brainstormed, Ryan and I brainstormed this as a topic that might be of interest to you guys. We want to empower you to, if you have something that you think you need to be brought to the court, that you talk to your program and maybe start looking at doing a motion and maybe being stretching our advocacy a little bit, we'll call it, and doing motions practice with your courts. So here's kind of the overview of what I'm going to talk about today. Just some kind of general information about motions, what it is, how to prepare to file a motion. There's some background work that you kind of need to do before you get ready to go. How to draft a motion itself, the important things that a court's going to want to see when you're making an ask, and what kind of documents accompany that. And then talking a little bit about kind of the back and forth pleadings that you'll see. We'll talk more in depth about that, but it's, we file a motion, a response, there's a reply, all that kind of stuff. And then presenting a motion in court, how to actually physically go to court and ask the court for whatever you're asking for. And then some other kind of miscellaneous details that I thought of that were related to motions practice. Okay, so a couple of important notes, and I hope this kind of theme, you'll hear me probably say it multiple times throughout the presentation, but a couple of things, a lot of what I'm going to talk about today is specific to Pierce County, because obviously that's what I'm familiar with. Every county does things a little bit differently. You guys probably know that based on all of the other trainings and everything that you've done. So my big kind of red point there is become at least marginally familiar with your local rules. Your program is probably familiar with them as well. So this could also just say, talk to your program coordinator. But basically all counties in Washington have they're called local civil rules that typically address just the specifics of filing motions in your county. So I know if you attended guardian ad litem rules with Ryan yesterday, he mentioned, local rules are kind of the procedural, logistical stuff about your county. That's what I'm talking about here. So it tells you actually like where to file things, how long you have to file things before a hearing is set, page limits, what kind of hearing dates you have. That are available. Those are all typically dictated by local rules. Like if I would say, I'm actually working on one right now, but I have a guardian ad litem came to me and said, hey, I want to file a motion on the lavender docket. I'm like, okay, great. Well, we know lavender in Pierce County, lavender docket is Thursday morning in JCD3, which means that looking at the calendar, I have to do it 7 days in advance. So the earliest I could get it on is the 10th. And so it's things like that that are very specific to your county. So just kind of talking with your program about that, get an understanding of what your county specifically guides with regards to that. And there it is right there. Your program staff will be able to walk you through how to get your motion where it needs to be heard in front of the court. So everything today that I'm talking about is specific to our county, Pierce County, and how we do motions. So your county probably does things differently. And your program staff is the best resource for kind of how to get a motion in front of a judge if you need to. Okay, so what is a motion? I actually had to look this up because I kind of know what it is in practice, but I was looking for the real definition. So Black's Law Dictionary is kind of the defining dictionary of all legal terms. And they define a motion as a written or oral application requesting the court to make a specified ruling or order. So essentially what it is you are asking the court to order something, whether that's to order a party to do, most often it's to order a party, one of the other parties to do something, or it's making just a general order that all of the parties have to follow. So motion is when you're specifically asking the court to issue that decision and issue that order. Okay, so here's some of the most common motions that we see in dependency cases based on my experience and what I've seen specifically. Motion to amend placement, that's a pretty common one. Whatever that looks like, whether it's a motion to amend placement to foster care, to a relative. The one I'm working on right now is a motion to amend placement to in-home with mom. So anytime we're moving a child from place to place, we're looking at a motion to amend placement. The one big exception to this is if a child is in kind of the category of foster care. Generally, the department does not have to do a motion to move a kid from one foster home to another. The court grants some authority to them to have a kid just kind of in the general foster care category, and then the department can move a child between placements within that category without coming to the court. Motion to amend visitation. Usually there, at least in our county, there's expansion language, we call it in our orders. So we can expand visits, whether that's make them like from supervised to unsupervised or more time or more frequent visits. We can agree to do that as parties, but anytime that we want to kind of restrict visitation a little bit, if we want to add some supervision or we want to make it virtual instead of in person or something like that, typically you have to go to the court to ask for the court specifically to order that. Motion to dismiss a dependency. When a child's been successfully home for 6 months, we can talk about dismissing a dependency. Motion to appoint a youth attorney. If you're not in one of the counties that started the rollout program, if we have a youth that we think needs counsel, we will do a motion to appoint the youth an attorney. Motion for guardian ad litem or advocate withdrawal. Typically in our program, we are assigned to every single case unless it's a teenager who's represented by an attorney, or if the youth is legally free and the adoption's on track and it's ready to go, then sometimes we'll withdraw from those as well. So we have a conversation about that, but then we do an advocate withdrawal. Motion for medical treatment. So typically this one it's the department's responsibility, but we have times where for whatever reason, the department doesn't get it done and the hospital, maybe saying, hey, this kid needs the procedure next week, what's going on? Then we'll do a motion for medical treatment and we'll go ahead and get the paperwork from the doctor and get the court to authorize whatever medical care is needed. I see a question in the chat. Can we motion for a change of an attorney for the kiddo? Typically, no. In Pierce County specifically, the answer is no. You would want to talk to your program about that, but it's kind of like how they can't ask for they could ask for a different advocate on the case, but we would say, no, that's our program's prerogative to assign whoever we deem appropriate. Same kind of thing with attorneys. So whoever does the assignment of attorney for a kid in your county, they've got some discretion to assign whoever they think is appropriate. The child themselves can ask for a new attorney, and how that works depends again on your county. There's also depending on the organization that's handling the youth appointments, if it's the Office of Civil Legal Aid, there's a form on their website, I think, that you can fill out if the child can fill out if the child has concerns about how their attorney is handling their case, and then sometimes that'll get review. But generally speaking, just like we can't ask for a new social worker, they can't ask for a new guardian ad litem or advocate, we can't really ask for a new attorney. Okay, and the other one, motion to continue. So that's if there's a hearing date and for some reason we can't go forward on the date that it's scheduled, we can do a motion to continue, which is basically just to reschedule the hearing. Okay, uncommon motions in dependency cases. So these are ones that I have actually done. That's why they're all listed here. But just kind of some random ones. You know, sometimes my team will come and ask me and say, hey, can we do a motion for this? And generally speaking, my answer is yes, we can do a motion for almost anything. So here's some examples. Motion for travel. We've got a kid who wants to, you know, a lot of times the department handles this one, but motion for travel, motion for name change, we've done those. Motion to allow unsupervised contact with a relative. Motion to amend the permanent plan. Motion for relative genetic testing. We've actually done this a couple of times where we've had an alleged father that we can't locate, but we have like an alleged paternal grandmother who wants to be placement. And so we've actually asked the court saying, hey, we can't find dad to paternity, you know, to parentage test him. Can we test grandma, alleged grandma, and see if she's a relative, she can be classified as a relative caregiver. Motion for homeschooling, motion to compel an FCAP assessment. So that's the University of Washington with Harborview does a foster care assessment program assessment, I believe is what it's called. And they basically do kind of a holistic review of the case and give some recommendations. Motion for a haircut. We actually did a motion to require DCYF to pay for new glasses for a child. They were refusing to pay for glasses. Driver's education. Motion for reconsideration is basically if the court makes a ruling and you believe the court made an incorrect ruling, you can ask the judge to look at everything again. That's called a reconsideration. Motion for revision is when a commissioner makes a decision and then that you ask a judge who's like kind of a little bit higher up in the hierarchy of judges. You ask the judge to actually look at it. I have one of these that's pending right now. Motion for clarification. So if something's confusing about a prior court order, you can ask for clarification. Substitute out of county court appointed advocate. We had one where it was a transfer case. So it came, I think, from Thurston County up to Pierce County. And we wanted to allow the advocate who'd been on the case the whole time to be in our program, to be on the case in our county. Motion to compel ICPC, motion to cease adoption recruitment. And most recently, we did a motion for return of child's personal items. Dad was refusing to give the child some of her things, and she had a very specific list. And so we asked the court to order him to do that. Okay, so we're starting now on the nuts and bolts of kind of getting ready to do a motion. So this is kind of the preparation section. So before doing anything else, talk to your program staff, your program coordinator. They've probably managed an issue similar to this before, if not this exact same issue, and they can help guide your request and help you figure out the best way to get this done. They also know the local rules and the best way to actually get the issue in front of the court that needs to hear it. So this is typically whenever my people come to me and they're like, hey, I want to do a motion, I ask them two questions to start with. First, have you talked to your supervisor about this? And then second, have you actually talked to like the parties on the back end before we kind of air it all out in court? Have you talked to the other parties to see if we can work this out before we bring it to court? So that's my second big bullet point there is before you actually start to work on your request, have you asked the parties if they agree with what you're asking for? So judicial economy, the court time is really precious and it should be treated as a last resort. If we can work it out behind the scenes amongst each other, I think that's always preferred by everybody, especially by the court. We can often get things resolved collaboratively. And if the request is something that the court has to order, so sometimes everybody agrees and that's great, but we still need the court to actually sign a piece of paper. They need to sign an order for it. So if we can get agreement for something, then that can dictate whether the court can sign an order ex parte without a hearing. So sometimes say we all agree that yes, this child needs this medical treatment, but the hospital needs a piece of paper with a judge's signature on it that says yes, this child can have the medical treatment. So a lot of times we'll all work behind the scenes. There's lots of emails that go back and forth. we'll all work it out with each other and then everyone agrees. And then we just submit the paperwork to the court without a hearing and the court will sign off on it. So again, it's a little bit of work on our end because we still have to do the paperwork, but it's also something that then saves some court time because we don't have to take the time to go in front of the judge, explain what's going on and all that. The judge can do it in chambers without being actually on the record. So for example, in the last screen, we talked about that motion to return a child's personal items. We had asked the parents' attorneys 4 times with like an itemized list of, hey, here's the things that the child wants, and they just flat out didn't respond to us. And so at that point we said, okay, this is, we need to bring it to the court. And of course, all of the emails where we had asked for it were attached as exhibits to the motion to demonstrate that, hey, we tried to work this out beforehand. What actually happened in that case is, as soon as we filed the motion, the parents' attorneys contacted us and said, oh yeah, we'll work it out. So I left it on the calendar because I said, hey, that's great, but let's, I'm going to keep this here as a placeholder until we've secured the items. And we secured the items and then I struck the hearing. But so that's an example, is we had asked multiple times before we brought that to the court. Okay, so preparation. So now that you've talked to your program, you've tried to work it out with the parties, and a lot of times, some of the things that we can't specifically work out with the parties are things that like the department by policy can't agree to. So it's like, if we want to move a kid to a home and there's an uncle who lives in the home who we're still waiting for his background check. The department can't agree to that until his background check comes back. But if we want to move the kid now, that may be something the department can't agree with. So that might be something that we need to do a motion on. So I'm going to put a document here into the chat. There we go. Okay, so these are called motion questionnaires. And these are, this is, oops, there it is on the screen. Okay, so these are documents that are, I developed these for our program, so this is proprietary information. But these are things that I've just put together that I'm sharing with you guys. But it's some questionnaires that can be helpful in guiding and organizing your thoughts as you put together your request. So what I've included here are the 6 that we regularly use in our program. So I'm gonna, whoops, not that thing. I'm gonna go ahead and move that over here. So these are all in PDF format. It's one right after the other. But it's, if I was staffing a case to, for example, the first one here is motion to amend placement. If I was staffing a case, these are the kind of questions that I would be asking my advocates. The kind of information that I think the court would want to know when the court's making a decision about changing placement. So it is, and this too, the other thing I should explain here, this is both for bringing we use the same kind of templates for bringing a motion and then also for responding to a motion. So if like the state has brought a motion and we're responding with a declaration, we use the same kind of template because it's kind of the same things that specifically we're talking about. So starting off right up front, what do you agree? Should this child move? Should this child not move? And then what materials have you reviewed to prepare the response? So typically it's, I got some examples there: state's motion, declaration of social worker, caregiver reports, etc. And then some questions about the current placement. So where is the child currently? How long have they been there? What placement number is this for them? Do they have siblings there? Is this like a relative or foster care? And then what exactly, number 4 there, is what exactly is the recommended change? So is it a change from foster to relative, relative to foster parent, etc. And then why is the change being requested? So is it, the caregiver can no longer provide care for the child? Is it the parent has done all of their services, they're ready to have the child in home? Just basically the reasons for that. The other one there is like, is there a timing component or a deadline? Sometimes we'll have caregivers who say, hey, I need to have this child moved by the end of the month. That's something important for the court to know. Is there a reason that we're asking for this now? Has there been a staffing? Has there been an FTDM, a family team decision-making meeting to discuss this change in placement? And then what have you learned about the new placement? Part of our role is to investigate, if a new placement's been proposed, go and visit and see what it looks like. So what did you observe when you were there? Did they have a room ready for that child? Did they have all the supplies they need? Have background checks been done? Are there any concerns there? Is there any services or safety plans that you would recommend to help facilitate this new placement? Are there any alternatives? Were there other relatives that were considered or anything like that? What does the child want? Is the child, is the child old enough to explain where they would like to be? And then ultimately, as is kind of our overarching objective, is what's in the child's best interest. So is it in this child's best interest to undergo this placement change? So what I typically do is, if we're working on emotional amend placement, I will send this to my guardian ad litem or my advocate. They'll kind of send me some bullet points that address these, whatever's relevant, and they'll send it back to me, and then I put it together in a declaration. So most likely, I would guess your program staff is going to be helping you put this together, but this is kind of a way for you to collect your information and your thoughts that you can get to your program, so then they can help get it in the right format for your court. So the next one here is amending visitation. So you'll see these all kind of have a similar flow to them, but what's your position on the request? What materials have you reviewed? What's the current kind of like status quo? What's visitation at right now? And then what's the change that's being requested? For visitation, it's, are we talking about the level of supervision? Are we talking about the frequency or the duration? Are we talking about adding in like a service or making it therapeutic, something like that? Why is there a change, a request to change the visitation? And then what does the new proposed visitation look like? And then again, what does the child want? And then what's in the child's best interest? So that's the visitation one. There's dismissing dependency. So this one is kind of talking about like how long has the child been in home? How have they been doing in the home? When were you last in the home to observe the child? What kind of service has the parents done? And then again, we kind of always close with these last two questions, like what does the child want? And then what's in the child's best interest? Here's our withdrawal question. So this is, again, specific really to our program, but how old is the child? Where are they? Are they represented by an attorney? How long have they been in their placement? Is it stable? What's in their best interest? Are they adequately supported by the other adults in the case? We do have a medications and medical treatment one. So this is where we typically rely on some correspondence from a doctor or a dentist or medical provider. But basically, what's being proposed, what medical providers proposed it, what are the risks, is there some follow-up care set up, what does the child want if the child's old enough to articulate their feelings on the request, and then again, what's in the best interest of the child. And then this is our request for an attorney. So again, once the child, the statute's it's working in waves, but typically when a child is 12 or older, you have to have a conversation with them about the right to have counsel. So that kind of is the opening questions here. So how old's the child? Have they specifically asked, have you discussed this with them, and have they specifically requested an attorney? And then is there anything specific that they want the attorney to help them with? So that's placement, it could be placement, it could be visitation, could be their permanent plan, education, medication, any other specific thing the child wants help with. And then why is it, if you think it is, why is it in the kid's best interest to have an attorney appointed? So those are, like I said, those are the 6 that we use most frequently. So those are potentially something that could be helpful to you. And again, my folks typically just kind of give me some bullet points that address what's going on with that specific motion request. And then they get it over to me, and then I put it together in the format for them. So it's something that might be helpful for you to then have some talking points with your supervisory team and your program staff to work through that. Okay, so again, we're talking about preparation. So maybe you've done your motion questionnaire, you've got that ready to go. Think about exhibits. You may want to include some exhibits to your motion. And these are basically documents from other sources that can be helpful to identify the facts that are in your materials. They also relay information from other professionals that can support your motion. So an example that I see is sometimes if we're talking about changing visitation, and maybe there's been some observations made by the child's therapist about how visitation is negatively impacting the child. And so the child's therapist may be willing to write a letter that kind of details what they've observed. And that would be a great exhibit to include with your motion to say, hey, this isn't just me saying, hey, we need to stop visitation. This is another professional who's working with the child. Here's their correspondence that explains kind of their concerns about what's going on with visitation. So think about exhibits. You want to collect those and have those ready to go when you file your motion. You don't want to kind of file your stuff and then be like, oh, I'm waiting on a letter from the therapist. You really want to include it all together so they can review all of the materials at once. Okay, still talking about preparation. There's a lot of prep work for motions here. All right, so timing of the hearing. Take a look at your calendar. When specifically do you want the hearing to occur? Is there a deadline involved, like the child needs to be out of the current placement by a set date, or, you know, hey, we've got this medical procedure that's set for the date, same date? Is there another hearing upcoming in the case? So is there like a review that's next week? Could you set your motion to be heard at the same time as the review hearing? You know, like I mentioned before, for the purposes of judicial economy, a lot of times if it's, you know, a bunch of issues about one case, the court would prefer to hear them all at once. So that's something that most courts are typically willing to do, is to set a hearing to have all of the issues on one case heard at one time. And again, like I mentioned, your county may have very specific rules. I think there may be some counties that only hear motions on certain days. In Pierce County, there's the yellow docket, the orange docket, the red docket, the green docket. Maybe I already said yellow. There's the light blue docket, the dark blue docket, the purple docket, lavender docket, legally free docket. That might be it. Anyway, so depending on what we have 3-4 offices in Pierce County, DCYF offices. Each office is assigned to a different color docket. So it's like I can only set a case out of Puyallup. They only hear those cases on Thursdays. So if I want a hearing set, I've got to really look at a calendar and say, okay, when's the next Thursday that I can get this on? Because I can't have it heard on a Monday. They only hear these types of cases on Thursdays. So check with your program. I think we're a little complicated. You might not have that much complication when you're setting things. And in Pierce County, it's not, we have a written calendar, but it's really confusing. So it quite literally took me 3 years to figure out when to properly set things on what calendar. So, okay. So I'm going to drop another thing into the chat. This is called, it's called the Motion Suite Sample. But basically what it is it's a sample motion that I've redacted out all the identifying information. But it basically, we're going to kind of walk through. So I'm going to be kind of switching back and forth between my slides and then my document to kind of just show you what in the world does all this even look like. So we've talked about kind of the prep work. Now we're talking about actually drafting things and what that looks like. So the first, and this is, again, a lot of this is just kind of the order of how I draft things. And again, how we do it in Pierce County. So the first thing is called the notice. In Pierce County, it's called the notice of hearing. I know in some counties it's called the notice of issue. I think both Kitsap and Thurston call it that. So your county may call it something else. But this is basically the document that tells the clerk to put this on the calendar. So timing, again, check your local rules. The rules will tell you how many days notice you have to provide before a hearing is held. In Pierce County, we have to give 7 days notice. Some counties, most counties, I think are 6. I think we have an extra day in there, but again, check with your local rules, check with your program, and they can give you some more direction on this. This also tells you where and when the hearing will actually take place. So, oh, I actually have that right there. Okay, so this should be similar, if not identical, to what I dropped in the chat there with the sample. So I'm just going to kind of walk you through this and tell you what's going on here. So up here at the very top is going to be whatever county you're in. Here we are in Pierce County. This is your case caption. The other thing I should mention is, at least in our county, each entity, so DCYF, us, and then parents attorneys, our scheduling form, our notice of hearing, each one looks a little different. And this, I hate saying this, but this is the one that we've always used since I've been here. So that's the one that I continue to use. I have revamped it a little bit, but I think we each have our own kind of, it looks kind of different. So you can look at it quickly and you know who's filing it. So I know that if this pops up, it's our office that's filed it. It looks a little bit differently when DCYF files it. So I think it's just a quick way for the attorneys to know, hey, who filed this motion. So up top here is the caption. So it's the welfare of, child's name, date of birth, and then our cause number. So then this is basically the first party that we send it to is the AAG. And so this is their contact information right here. It's going to have their name, their address, their email. When I started, our forms didn't have email on there. So we've probably been using this form forever. So I added that in there. Their bar number, and then they're the Assistant Attorney General. So the nature of hearing, this is where we're actually saying what motion it is that we're bringing. So here, this was a guardian ad litem's motion to amend placement to relative care. Okay, so then here's the important part, date and time of the hearing. This was a yellow docket case, so we set it for September 7th at 10:30 a.m. JCD3 is just the name of one of our courtrooms. And then, of course, this is something we've had to add since the pandemic, but here, some of our motions are in person, most of them are still by Zoom. So I go ahead and I add, this is our Zoom link for our yellow docket. So I've added that in there. And then we have here, like I said, here, so these are all of the dockets that we have in our county. So I just checked the box, this is the yellow docket. And then this is my information here. So my name, my contact information, the date, all that kind of stuff. So this would be where your program, probably your program staff is going to be the ones who are signing this to set it on the calendar. This would be their info. And then here on this side, you put all of the parties, all of the entities that are receiving notice about your motion. So typically we have, the way we list it is we typically put the social worker and then all of the parents' attorneys and then the kids' attorneys. So it's basically you include the social worker and then any of the attorneys that are on the case. Their information gets listed there just to kind of demonstrate, hey, here's who I've sent it to. And again, I added email because that wasn't on there before, but yeah. So attorney, oh yeah, mom had 2 attorneys here and then dad had an attorney. So, and then, so then we've got the AG, social worker, and then all of the attorneys. So this document gets filed with the court and then also gets served on all of the parties. So however your offices do service, whether it could be probably by email, you probably have some sort of system worked out. And I think most counties in Washington state now are e-filing. So your program will know how to do that. So they file it and then they serve it on everybody. So that's your first document. That's your notice of hearing. All right, then we're going to go ahead and move down and talk about the motion. Just one other thing I should probably mention, but in our county, because I'm an attorney bringing the motion, I also file what's called a notice of appearance, a limited notice of appearance, which basically just says, hey, for the purposes of this hearing, the guardian ad litem or court-appointed advocate is represented by counsel. So I do an additional document in there because I'm the attorney stepping in that just says, hey, if there's any responses to this, or basically lets everybody know, hey, there's an attorney involved on this motion. So depending on your program, if you have some attorney connections or representation, that might be added in there. But I think most of you, it won't be because you don't have counsel. You guys are handling this on your own. So, okay, so talking about drafting, now we're talking about actually the motion itself. So generally this document is a concise statement of specifically what you're asking the court to do. So depending on the issue in your court, you may also submit briefing on an issue. So your program probably, they'll help you with this. They may have some stock things that are written out, or they'll sometimes they'll email me and ask me for some additional help. But briefing is where we talk about like case law and statutes and it's a little bit more robust of an argument. Most of our motions don't have those because it's really more about facts of the case as opposed to really some specific legal arguments. Sometimes we will, if it's a pretty substantial case, sometimes we'll do a little bit more briefing on it. And again, it's a more robust discussion of case law, statutes, rules, and your arguments. Sometimes we'll submit kind of the basic motion first, and the court will say, hey, I want some briefing on this. And so then the court will actually reset the hearing, and all of the parties will have to do a little bit more kind of legal analysis and submit that to the court in advance. Okay, so this is the second document that's in that PDF set, but this is our basic motion to amend placement to relative care. So just to orient you, here's what county we're in, Pierce County. The welfare of child's name, date of birth, cause number. This is the title of our motion here. So it would be guardian ad litem's motion to amend placement to relative care. It could be to amend visitation, could be to return child's personal items. That's kind of the title of your motion. And then basically this is just a concise statement of what we're asking the court to do. So here we're moving the court for an order that amends placement to relative care, in this case, paternal grandmother, and then we list her name. That's what's blacked out there. This motion is based on the declaration of the guardian ad litem as well as the court's files and records. And then it's dated, I sign it. This is my certificate of service here. So when I give it to my office staff, they sign off on this, which basically just says, hey, I sent it out to everybody. So that's kind of the basic motion of what that kind of looks like for us. Okay, drafting the declaration. So we're kind of working through our the documents that get filed with the court, filed and sealed with everybody. So declaration is a statement made under penalty of perjury that lists the facts and information that supports your motion. It may identify some of the case history if it's pertinent to your motion. For example, if it's like a motion to amend placement and it's a kid who's had, you know, tons and tons of placements before, that might be relevant information for the court to know. So you may want to kind of go through that history a little bit. It has to be signed by either the court-appointed advocate or the guardian ad litem who's making the declaration. This may, depending on your program may sign off on the paperwork for you, but we've actually switched, this last year, we've switched to having our advocates actually sign off on their own declarations. We use a program called DocuSign. If you've ever recently bought a house or anything like that, that's probably the program where you have to sign, 600 pages electronically, but that's similar kind of program that we use for our signatures. So that's and like I said, your program may sign off on it for you, or they may coordinate with you to come in and get you to sign off on it. So if you have exhibits for your motion, this is probably where they would show up. You would attach them as exhibits to your declaration. So again, that's any documentary evidence of what you've attested to in your declaration. So you may list there, hey, I spoke with a therapist and, she expressed concern about, this, and this. And then you can say, hey, attached as exhibit A is correspondence from the therapist that, identifies her specific concerns about this visitation issue. So some examples of helpful exhibits. For medical motions, if you have correspondence, most of the time the doctors will write a letter that says, hey, here's what I'm recommending and why. Medical records, if there's a specific, treatment plan that they've included in records. Sometimes for visitation motions, if you have family time reports, so you get reports out of Sprout or, directly from the social worker, those could be included as examples. And for a placement motion, again, you may have some correspondence if the child's seeing a therapist, they may have some recommendations. If you have like a couple that we did recently, we had FCAPs. So again, that foster care assessment program, they had done some assessments for us about where these children should be moved. And we relied on that as part of our motion. And so we included those as exhibits to our declarations. Be mindful that some exhibits may need to be sealed and viewable only to the court. This is things like home studies. So we have, we've done a few lately where we've moved kids on an ICPC. And so as part of that ICPC process, the proposed placement in the other state has a home study, which has a lot of personal information in it. And so you talk to your program, but what we've had to do sometimes is redact some and file an unredacted version, but then we file the full version under seal, which means that only the court can look at it. And so that way that sensitive information is really protected. Like for example, the home studies in Texas actually give like directions on how to get to the person's house. So we've redacted that out and then we file it under seal so only the court can see it. And that's something, again, your program can chat with you about to make sure that you get filed what you need to file and nothing that you don't need to file. Okay, so here's an example of a declaration that we worked on. So again, orientation is the same on all of them. We've got the county up here, child's name, date of birth, cause number, and then this is the declaration. So this is a guardian ad litem did it, but it would be the same thing that I would put together for a court-appointed advocate. So thinking back to when we were looking at that motion questionnaire, you'll see as we walk through this, you'll see kind of how we use that as a guide to put this together. So this is our request, is that we're amending placement to paternal grandmother. And then here's kind of the things that the guardian ad litem has done. So they've done a walkthrough of the home, they've reviewed they've been advised of the results of the home study. Here was one where DCYF hadn't given us the home study. So we were requesting to view that. Then here's where the child currently was. They were in foster care, how long they'd been in this home. They did have a brother, but there were some issues about the kids living together. So that was something that we were aware of, but we weren't looking to put the kids together because of the issues there. So grandmother had come forward as a placement option. There had been some concerns with grandma. And so grandma was referred by DCYF for a psychological evaluation. That came back favorable. The home study was great. And then this guardian ad litem went to the home for grandmother, was safe and appropriate. The room was set up. It was all ready to go for him. The grandmother or the guardian ad litem met with the kid. And there's a typo right there. The guardian ad litem met with the kid. The kid had said he wanted to be with grandma. There was an FTDM. The guardian ad litem understands that mom was opposed to the placement, and that father supported the placement. And then the guardian ad litem had some specific recommendations for the transition. So there was a WISE team involved, continued enrollment out of school. The school had helped create a 504 plan for the kid. Believe it's in the best interest of a child to be placed with appropriate relative caregivers. Kind of summarizing, the proposed placements overcome barriers, and then ultimately the guardian ad litem believes it's in the child's best interest that his placement be amended to relative care. And then my guardian ad litem signed and dated, and then the certificate of service was done by our staff when they sent it out to everybody. So you can kind of see, if you get a chance later to kind of look at this declaration and then look at that questionnaire, and you'll kind of see how they kind of track together. And quite honestly, if you pull up any declaration that we've filed, in the last 5 years or so, they kind of follow the same format that we've developed based off of that questionnaire. Okay. So we've done our notice of hearing, we've done our declaration, or our motion, we've done our declaration. The last thing generally that you have to do is a proposed order. So the moving party should draft a proposed order which reflects exactly what you want the court to order. So be optimistic and think that the court is going to order everything that you ask for and put it all in your motion and have it ready to go. So depending on the motion and what your court wants, you may also need to include findings of fact relevant to the issue. So typically this arises when there's highly contested motions with a potential for appeal. So if there's some findings, some decisions that the court's making that's pretty contested, it could kind of go either way, and there's a possibility that it could be appealed. Your court may want you to do a little bit more than just say the court's ordering this. They may have some specific things that they want in there. So I'll show you the document that I've included in here is kind of a more robust one here. And Pierce County requires this for any motion to amend placement. So anytime we're changing placement for a kid, the court wants like the full findings in there. So like I said, we'll go through that in a second, but the proposed order should have a signature block for each of the parties or their attorneys to sign. So it may be that they don't agree to the motion, but they agree that, hey, yes, this is actually what the court has ordered. So a couple of best practice tips there is always leave some blank, especially if you're in person with a paper order, your program's in person with a paper order, always have some blank lines in there to add things that the court may order during the hearing. A lot of times they'll do exactly what you've asked, but other parties may be like, hey, well, we also want to add this, or we also want to add this. So rather than like scribbling little notes in the margins, leave some blank space there so you can write things neatly and legibly. So if you have to come back to it in 6 weeks, you can see exactly what is written. The clerk's office also gets really picky if you write like too close to the edges, especially ours, because you can't scan in, it cuts it off. So leave some blank space in there just in case you need to add some things. The other best practice that I have is having your program send out the proposed order to the other parties a day or two before the hearing. I always do this so they can, I just send it out to everybody, say, hey, this is for the hearing tomorrow. This is the order that I'm going to be working off of as the court makes its ruling. So then that way they can see exactly what we're asking for, and then they can kind of track as the court makes changes during its ruling. So this is, like I said, this is one of the more robust ones that our courts are typically requiring for motions to amend placement. So here it's kind of got some of the case law here to start with, and it's talking about preferences for relative care for children in dependency. And I'm citing some statutes and some case law here that basically says, the court in making a placement decision for the child, the overriding concern is what's in the child's best interest. And then relative care is preferred in the statute. And then what I'm basically asking the court to do here is find some of the facts that we've presented. So the child's in foster care, grandma's been a placement resource, grandma has an approved home study, and it's not in the kid's best interest to be in foster care when there's an available relative to care for this child. And then making a finding that it's in the child's best interest to be placed with grandmother. And then the order is what you actually want the court to do. So in this case, the guardian ad litem's motion to amend placement is granted. The child's placement shall be amended to relative care with the grandmother. Then these are some of the things that we had mentioned specifically that we wanted the court to do. So the WISE team should continue to work with the child. He should continue to attend his current school. Oh, that's it. Okay, so those were the other two things that we specifically asked the court to do. And then here we've got the signatures for everything. So we've got here the date that the hearing was, spot for the judge to sign it. There's my signature block. This one we did by Zoom. So there were all of the attorneys that were present and that approved the order by Zoom. So this is ultimately also, especially like if you're amending placement. So this is the grandma in this case would get a copy of this order to show that the court formally amended placement of the child to her. So that is, I think, yeah, so that's all of the documents that are included there in that motion suite sample, that PDF that I submitted in there. I think a couple of people might have dropped in later, so I'll redrop them in the chat if I get a chance to. Okay, so that's kind of how you draft all of your paperwork. So once that's all been done, you're finalizing all of the documents with your program staff. Chances are they're going to be the ones who are drafting it, and they'll probably send it over to you to just take a look at, make sure they've got everything accurate, because you're the one who's actually gone out and seen the kid. So then talk to your program, work with your program, and they will make sure that all of the documents are filed, which is sent to the court and made as an official part of the court file. Again, I think every county now is doing e-filing. There may be some counties where they actually walk it down to the clerk's office and hand it to them, but your program will know and figure that out. Maybe, I'm not sure. There might be some. And then served, which is basically sent to all of the other parties. In Pierce County, we have two ways of doing it. So we have an e-serve, so we e-file everything, and then we also can do e-service through that. So the attorneys sign up with like an email, and then we can just click serve, and they get an official notification email. We also typically send our office staff sends them an email of it as well. We don't actually physically give hard copies to anybody, and that's an agreement that we all have with each other. So depending on your program and the attorneys in your county, you may just be able to email it to everybody. There may be some curmudgeonly attorneys who actually want hard copies of things, but check with your program, they know. Okay, so after you've filed all your stuff, you've got the hearing date set, Kitsap's still working on e-filing. Okay, I know, and that's okay, yeah. It's really efficient if you can get it to work well. So, okay, so everything's filed. You've got your date on the calendar. Unfortunately, you can't sit back and relax because you have to maybe respond to some things. So what's going to happen is after you file everything, all of the other parties has the opportunity to file their own paperwork in response to your paperwork. So timing, again, check your local rules for timing. So in Pierce County, the initial motion has to be filed 7 days before the hearing. Responses are due the 3 court days before the hearing by noon. And then we'll talk about a reply in a second. But I think we have 3 days. I think most counties have 2 days. So again, check your local rules, talk to your program. So each party, typically DCYF, the parent or the child, can file and serve what's called a response to your motion. So this may be in support of your motion. They may say, yeah, we agree this child's placement should be amended. Or it may be opposed to your request. So it may be, no, we don't think this child should move, and here's why. So make sure that you review any responses before you go to court, so you are prepared to address what they're actually going to argue in court. Depending on your county, if a response is not filed timely, so if they, for example, they file it the day before the hearing, that's not technically timely. Some courts may just not consider it. They may say that wasn't done timely, we're not going to consider that. They may continue the hearing to give everybody time to review it and respond. in Pierce County, we just kind of have an understanding that responses are going to be filed late and the court's going to consider them. So it just depends on your county and kind of how things operate. There are technically deadlines. It's kind of up to your court if they actually follow those deadlines. Okay, so the other parties get to do the response. And then what happens is, as the moving party, you kind of get the last word. And so you can file what's called a reply. So again, check your local rules for timing. Our replies are due the day before the hearing by noon. So it goes initial motion, response, and then reply. So again, as the moving party, you get the last word. It's kind of like a, initial argument and then a rebuttal, and then kind of back to it's like on cross-examination, kind of goes back and forth. So again, a reply document, it's usually short, but addresses two things: any opposing arguments that have come up in the responses. So if they don't want the kid to move and they have specific reasons, you could address those. And then just, again, a reiteration of why the court should grant your request. Okay, so confirming your motion. Again, check your local rules. Some counties require you to confirm the motion a number of days before the hearing is actually set. If you don't confirm the hearing, the court just strikes your hearing. Again, this is some counties, not others. We don't have to confirm anything in Pierce County. Once we set it on the calendar, it's set. I think, I don't want to speak out of turn, but I think, like, I know Kitsap, you have to confirm civil hearings. I'm not sure if you have to for dependency cases, but really just check with your county, check with your program staff, and they'll make sure that it gets confirmed if it needs to be for you. That's the worst thing, is finding out that your hearing's not been confirmed and you show up ready to go and it's not on the calendar. So your program will work on that for you. Okay, so everything is all set, all the paperwork is in, you're ready to go to get ready to argue your motion. I always prefer to have my advocates with me in court when I'm arguing the motion, because you're the one who actually knows, like, all of the facts and all of the things that are going on. So if all of a sudden, a parent's attorney is arguing, well, no, they had visitation last week and it went well. I don't know if they had a visit last week and it went well, but you probably do. So check with your program. Your program will probably send staff with you, but then typically we also appreciate having you there because you know the ins and outs of the case better than anybody. So before the motion hearing, you want to review everything that you have filed. So that's your motion, your declaration with your exhibits, any responsive documents that you've gotten, and your proposed order. You want to just take a look again at everything. Assume that the court's reviewed everything that has been filed. I've been very, okay, so it's been very few times that a court has actually not read something that's been filed. If it's late, sometimes they won't have a chance to review it, but most of the time courts are really, really good about filing things. Okay, so prepare some bullet points of your key arguments. We want to make sure that you have specific things that you want to argue. And again, you're assuming that the court's read everything, so you don't have to reiterate everything. You just need to have some key bullet points. Okay, so whoops. Okay, so this is actually when you are arguing your motion in court. And again, the same kind of thing is going to apply if you are on Zoom, if your courts are still doing things by Zoom, or if you're doing them in person. So you want to open the hearing by identifying yourself and identifying and also, as is my kind of theme throughout the case, talk with your program beforehand about, they've been in court many times on motions and they can kind of give you an idea of how it goes. Again, kind of what I'm talking about is what Pierce County specifically does. So your county may be a little bit different. So open the hearing by identifying yourself and your role and identifying exactly what you're doing, asking the court to do. So, Your Honor, we're requesting that Amanda's placement be amended from foster care to relative care with paternal grandmother, Barbara Miller. There's no question there. That's exactly what we're asking the court to do. Working from your bullet points, make a record of the important information that's informed your recommendation. Do not just read your declaration into the record. The court's read it, the parties have read it. Nobody needs to hear it word for word again. Okay, there's some probably specific important bullet points that you that you really need to highlight for the court to make your record, but that typically doesn't involve reading everything all again. So close this part of the hearing by reiterating your request and looping in the best interest advocacy, which is what our entire role is. So, Your Honor, we believe this proposed change in placement to paternal grandmother, Barbara Miller, is in Amanda's best interest at this time. Thank you. So you open with what you want the court to do, you fill in all the information, and then you close it by saying, again, here's court, here's what we want you to do, and it's in the child's best interest for you to do that. Okay, so then the court's going to ask to hear from the other parties to the case. So DCYF, parents, child. So again, the parties to the case. And then if there are others present regarding the child, they may ask to hear from other people. So that could be caregivers, if there's caregivers present, relatives, therapists. Sometimes a therapist will actually come to court and talk, visitation supervisors, etc. Listen to what the other parties' arguments are making. Again, you should have an opportunity to review their reply before their written reply or written response before the motion. So you should know what they're going to argue, but really listen to it. So if they make specific arguments for or against the motions that you want to address, like make a note of it. You don't need to address everything that they argue, but if they really are going after one specific point that you really want to clarify for the court, make a note of that. Keep a neutral face and demeanor throughout the hearing, even if you disagree with the facts being presented or the arguments made. Do not interrupt. The court has to give them an opportunity to speak. And then typically, because we're the moving party, the court should offer an opportunity for you to speak again at the end. We kind of get the last word because it's our motion. And there it is right there. So as the moving party, the court should let you have the last argument called a rebuttal. Sometimes it depends on your court. Sometimes it depends on your judge. If you have a docket that's going long, the court may not be willing to hear from you again. But if you have something specific that you need to address, let your program staff know and they can speak up and make sure that the court lets you speak again if you need to. So when you have your opportunity, your last word, concisely address any of the arguments made by the other parties, and then close the hearing by again identifying exactly what you're asking the court to do. Your Honor, we respectfully request that this court find that the proposed change in placement is in Amanda's best interest and that this court grant the court-appointed advocate's motion. Thank you. Okay, so you've done your piece. You've given the court a recommendation. You've given the court all the information. Now the court has to make a decision. Typically, the court, at least in Pierce County, will issue its ruling from the bench. So we've had a few times where the court says, hey, I need to go review some more materials. I'll issue a decision later. But most of the time, it will issue a decision as it's sitting there. The court will generally give an explanation for why it's ruling the way it is, and then we'll discuss its decision. So as the court makes its ruling, take some notes on what the court is actually ordering so that you can modify your order as you need to or add things that the court has ordered. Perfect scenario, they order everything that you've said. Okay, there we go. Recording stopped and then recording in progress again. So if you're in person, that's handing the papers around to all the attorneys to sign off. If you're electronically or by Zoom, we typically will just circulate emails and we'll send the documents by emails. And it takes a little bit longer for everybody to review it, but that's how we get the court to sign off on it. And then it gets submitted to the judge's assistant or the bailiff, and then they get it to the judge to actually sign. Okay. Couple of miscellaneous things that didn't really have a good place to fit in otherwise, but do have to do with motions. So shorten time. So if you have an emergency issue that needs to be in front of the court as soon as possible, and you can't wait for a regular hearing date, you may need to talk to your program about doing something on shortened time. So again, check your local rules, talk to your program staff, because most counties have some very specific guidance around shortening time. Typically, it requires you have to file a second motion. That's called a motion to shorten time. And that's basically saying, hey, this is why this is an emergency issue that we can't wait for. So the court will either grant or deny the motion to shorten time. If the court grants the motion to shorten time, then the court will hear the actual motion. So say, for example, you have a child who needs their placement needs to change by the end of the week, up, by Friday. That's not the set, we won't be able to set a hearing until next week. And so we would need to ask for shortened time. And we would explain, the child's placement is ending early on Friday. So we need to have this heard before that date. So if the court grants the motion to shorten time, then the court would hear a motion to amend placement. Then the motion would have to be set on regular time with appropriate notice to the parties. So again, talk to your program. These situations should be relatively few and far between. Most of the time we can work it out timing wise, but this is something that does come up occasionally. Ex parte, another miscellaneous thing. So I mentioned this kind of at the beginning, but if something is done ex parte in this context, it means legally, definition wise, on or from one party only, usually without notice to or argument from the adverse party. In practice for us, generally this just means without a hearing. So if all parties are in agreement with a motion, the court may be willing to enter an order on an ex parte basis. So you'll work with your program staff, reaching out to all of the other parties before you file your materials to determine if everyone is in agreement. If yes, then your program staff will be able to facilitate entry of an order on an ex parte basis. So for us, the most common ones that we see on an ex parte basis is appointment of an attorney for a youth. So everyone agrees to appointment of counsel for a child, and then we get that submitted to the court without a hearing. Same with if we are asking to be withdrawn from a case. A lot of times everyone will agree to that ex parte, and then we can just submit it to the court without a hearing. So that's kind of my general run through on motions. I'm going to go ahead and put those two documents back in the chat, just so if there were some latecomers, they still have them. Let me see here. Everyone in the meeting. So again, this is just the motion suite sample and then the motion questionnaires, which are just two documents for you to save to help you if you are in a place where you are interested in doing a motion. So before we switch over to our next topic, I want to have an opportunity to answer any questions that anybody has. Yeah, copy of the PowerPoint, you bet. Let me drop that in there too. Which ones is it? Oh, no, I got to close my file first. Okay, here. Stop sharing. Okay. Okay, let me close that. Okay, PowerPoint. Okay. So okay, so question, do all legal parties have to agree to the date for a motion on shortened time? So that depends, again, on your county. So in Pierce County, we have actually a very drawn out process. If you want I'm just going to explain it just to give you an example. If you want a motion on shortened time in Pierce County, what you have to do is you have to email the other parties and say, I would like to bring, for example, a motion to amend placement. I want it to be on shortened time. Here's the proposed, I would like to have this heard tomorrow or whatever. Then you have to give all of the parties 24 hours to respond to your email. Either they agree or they don't agree. And once you've heard from everybody after 24 hours, then you can email the judge's assistant and say, I want to do a motion on shortened time. I've polled all the parties. Here's all of the questions that I've got. Here's all of the responses that I've got. Here's who's opposed. Here's who's in favor of it. And you just kind of give all that information to the judge's assistant. And then the judge takes a look at that and says, yes, I'll hear it on shortened time, or no, I won't. If they say yes, then you file your notice of hearing, but you have to attach the email approval from the judge's assistant, or else the clerk's office will reject it. And then you got a motion to shorten time set on the calendar. So again, you can see that's our developed process here in Pierce County. So it's very, very particular. You probably need to talk to your program specifically, and they can let you know. I don't know if anybody else has as complicated a process as we do, but your program will be a better resource to give you exactly what you need to do. But like I said, sometimes we have a party who says, no, I don't agree to have this heard on shortened time, but our court will hear it on shortened time anyway. They'll note the objection, but they'll say, it's an emergent situation, we need to hear it. So, all right. Okay, so we'll take a few more questions and then we'll probably take like a 5-minute break, 5 to 10 minute break, and then we'll hop on the second PowerPoint that we're doing today. So any other questions specifically about motions practice? Going to the PowerPoint, let me see. Okay, I'm gonna add in, I know that I'm not so great with the PowerPoints here. Okay, so I'm sending the PowerPoint. So you should have out of this, and I can send it to Ryan too. I'm sure that he's sending out documents to everybody. So we'll make sure that you guys get that in an email too. But I've uploaded to the chat both the PowerPoint, it's called Motion Practice for GALs, and then the motion questionnaires, which is a PDF, and then the motion suite sample, which is also a PDF. Oh, yep, Ryan says they'll be posted on the website soon. Great. So if you don't save them out of the chat, they'll be in your materials that you can pull off the website. Cool. Okay, so it is 2:08 by my clock. So maybe we'll take a little break and come back about 2:15, and we will talk about how to testify. It's 10 tips and tricks for testifying in a termination trial. So more legal stuff, but we'll be back at about 2:15 if that sounds good to everybody.